Like I said, I find that most cases can resolve at mediation. I like mediation as a confidential process, so the judge is never going to know what happens at mediation. I find that we can get more creative than a judge might do because the judge is going to follow exactly the law. And I'm not saying we go, outside the law, but we can get more creative. I also am collaboratively trained, which is the collaborative process is an agreement between the parties that we're not going to litigate this case. And it's handled a little bit different. And I find that collaborative process can work really well.
Welcome, everybody, to the Mark Ramey Podcast, where the intention of this podcast is really to shine a light on successful local businesses, learn their story, understand how they became successful, gain insight into their area of expertise, so that when we have a need, we can connect with great people that'll serve our needs. And I think highly of Lorna Truett. She served my clients over time. I do know that she's accredited. She's Orlando's Attorney of the Year 2019, Orlando Style Magazine. Super Lawyers Rising Star 2018, 2019, 2020, 2021. Wow, during the pandemic. Florida Trends Legal Elite. She's an awesome attorney here locally in Orlando, and she practices family law. We're really grateful to have you here today.
Thank you, Mark. That was quite the introduction.
Well, when you earn it, you get it. So let's dive right in. The first question that I have, tell us about yourself, how you came to practice law, and maybe what drove you to become passionate about family law.
So I'm actually a Florida native, and I started out not planning on a law career. I graduated from Rollins College and was working for family law lawyers in town, very respectable lawyers. And I worked there for 10 years and really felt like I could do this. And so I went to law school when I had two small children at home. I started law school, my baby was 6 weeks old, and I had a 2-year-old. And I stayed home with them during the day and went to law school at night. And I still worked on the weekends for my former boss, the family law lawyers, assisting them with their books at the time. And after law school, I went and worked for another attorney focusing on family law and criminal. But family law has always been my passion.
That's amazing. I wrote down you had a 6-week-old and a 2-year-old.
And a 2-year-old.
And you started law school.
And I started law school.
And you were working, was it full-time?
No, just part-time.
Okay.
Part-time.
Wow. I was going to say, you got an S on your chest. That's awesome. So tell us a little bit, what are like the main steps involved in the divorce process?
So, well, it really depends. The proper way, when you say steps, like how to start a case or, I mean, the proper way is that you would file the petition for dissolution of marriage and serve it on the other party. They would have 20 days to respond, probably file their own counter petition. Most counties, it's a requirement that you go to mediation before you litigate, unless there's an emergency, obviously. I find, and also just so you know, I'm also a Florida Supreme Court certified family law mediator as well. But I find most cases really can resolve at mediation. I believe in mediation. We have a lot of great mediators in town, but they don't always resolve. And so I've actually been litigating a lot more recently, and I don't know why that is. I don't know what's going on in the air right now, but I'm having a harder time getting to resolution. And it's been since post-COVID, and it's just something, a lot more trials. But so that's the process. If you can't resolve it in mediation, then you go the litigation route.
Okay. I'm curious, are there steps, if I'm getting a divorce, are there steps that I should take prior to filing a divorce to make the process smoother?
Well, I like to be as amicable as possible. So I think, talking to your spouse, if it's not high conflict case, talk to your spouse, try to figure out what you want. Obviously we have what's called mandatory disclosure in every divorce case, which is just an exchange of financial information. And in most cases, we have to do what's called a financial affidavit. So it may help you to start gathering that information. It certainly helps the attorney if you've gathered all of that information and organized it in a way that we can use it. It's very helpful to me and my paralegal when we get all the financial information and it's already organized. And we like to tell our clients what we want that to look like.
You're leading right into my next question, which really is, what records should I take with me to my first appointment with my divorce attorney?
You really don't need to bring anything with you to your first appointment. But it also can't hurt to look at that mandatory disclosure checklist, start gathering your tax returns, pay stubs, bank records, credit card statements. Something people forget is a lot of us have this virtual currency now, like Cash App and PayPal. Gather those records. I do everything electronically if I can. So for me, my preference is I don't even need a piece of paper. Pretty much everything is electronic these days. And in fact, we are filing everything electronically these days. Your marital settlement agreements, everything, we don't have hard copies. It just goes straight into the cloud to the clerk of court.
Wow. So it's becoming easier. I guess if I'm the party in the relationship that doesn't typically handle the finances, like in our family, how would I go about getting copies of the bank records and credit card statements if, like, maybe we're not communicating really well?
Right. So there's a number of things we can do. One, you're entitled to know what everything is, and your spouse has a duty to provide that information. So if you don't have access, they're having a duty to provide it to you. Sometimes people are hiding the ball, and I have the power to subpoena records directly from the banks. And so that's another way of going about it. If we can't find the information, if they're not providing it, or if we think that they're hiding accounts, I can go straight to the source and subpoena the records. Okay.
That sounds like a lot of power, but it needs to be used when someone's not cooperating.
Right. And judges don't like when you aren't cooperating, because, if you're not providing the documents and I have to file what's called a motion to compel, take you to court to get the documents, it just causes my client money unnecessarily. And that party that's hiding the ball will likely be on the hook for some of my attorney's fees because we've had to chase the documents. And it does happen a lot.
There's a way to see that it's done fairly.
Right.
That's awesome. I guess when you speak to people that are going through divorce, what are their primary concerns that, they might have when going through the divorce? What comes up?
Well, again, it's sort of case specific. For me, obviously if there's children involved, that's the most important is what are we doing for the children? What are we trying to do? What is the time sharing schedule going to look like? We have an administrative order in Orange County that talks about, immediately it's going to be a shared parental responsibility case. Both parties need to be exercising time sharing. And if there's some reason that you're not doing an equal time sharing schedule, you better be prepared to prove that up for the court. Because we now have a new statute in Florida that talks about equal time sharing, and I'm paraphrasing, but equal time sharing is the presumption is it's in the best interest of the children is equal time sharing. It is a rebuttable presumption because it's not every case that equal time sharing will be. And in fact, I've already litigated a case that's a statute that I was able to overcome that presumption.
Oh, wow.
But obviously, if children are involved, that's to me always the most important thing. And then protecting assets. If you have a concern that the spouse is, has been preparing for the divorce and trying to hide money. The admin order talks about that too, like preserving assets. It can get challenging at times because I find that our judges don't look at financial matters as emergencies. And if you have the spouse who's not the breadwinner and the other party's kind of trying to starve them out, it can be very challenging that you're trying to get to mediation as quick as possible to address these issues. Because again, we're supposed to mediate before we litigate.
Yeah, that's tricky,
Mm-hmm.
especially when it comes to, I don't have the money to support what I need to do this week.
Right.
That's a challenge.
Right.
Wow. So I always hear the phrase, that's grounds for divorce.
Mm.
I don't know if I hear it on TV. I don't know, if how meaningful it is. What does that mean for you? I mean, is it something?
I mean, I pretty much all of our petitions essentially just say the marriage is irretrievably broken, and that's the grounds for divorce. At the final hearing, the judge may want a quick statement as to why is the marriage irretrievably broken? And it can be as simple as my spouse and I can no longer live together. It doesn't need to be some drawn out thing.
So we don't necessarily have to go through the Judge Judy process.
Right.
It can be, this is where we are in our relationship and we're ready to move on with life.
Right. It's just a pretty simple statement that the marriage is irretrievably broken.
So it's not like one person did this and they'll have a stronger case and maybe to have a better outcome. It's not necessarily going to work that way.
Not necessarily. I mean, pretty much in Florida, we're going to look at what are the marital assets, what are the marital liabilities, and in most cases, we're just going to divide those in half. It's there are reasons that you can do unequal distribution, but for the majority of the cases, this is going to be an equal split.
Okay, that's helpful.
Mm-hmm.
Now, I heard that there's been some recent changes to the alimony laws.
Mm-hmm.
Can you tell me more about that?
There are. So we historically had permanent alimony. We no longer have permanent alimony. And we still have durational alimony, bridge the gap alimony, temporary alimony, which is during the pendency of the proceeding. And what am I saying? Sorry, the statute just changed where without the permanent alimony, we have a formula for alimony now that puts a cap on the amount of time, the length of alimony, and the amount of there's a formula for the cap of the amount it can be.
Okay.
Sorry, I'm stuttering on that for some reason.
No, it's I heard it was new.
It is. As of July 1st of this year.
Yep.
Yeah, they've been trying alimony reform for years, and this it finally passed through.
Woo!
Along with the new statute regarding the presumption of equal time sharing for children.
What if I recently received an inheritance? How should I handle that prior to a divorce?
I always keep it separate. Never commingle inherited money with your spouse. And that because it's a non-marital event. And if you commingle an inheritance in a joint account, you took what was a non-marital event and made it a marital event. Meaning that now your inheritance is part of the pot that we're going to look at when we equitably divide the estate.
So then that could become part of my planning. If I'm seeing that I'm going into a divorce down
Mm-hmm.
the road, then, maybe the money that I received from my father when he passed, I just need to have a separate account.
Keep it completely separate.
Okay. All right. What child-related aspects do the people inquire about, like, the most during divorce proceedings?
What do you mean?
So, in other words, if there's a concern about, well, I have a dear friend of mine, and her husband, it's not good for him to be around the kids.
Mm-hmm.
And really, when the kids are there, it disrupts their lives. Is this 50-50 timeshare something that can be overcome?
It can be overcome. And sometimes we have to get guardian ad litems or third parties involved to, meet with the children, meet with both parents. They can talk to teachers, and they can make a recommendation what he or she believes are in the best interest of the child. Because ultimately, yes, the presumption is 50-50, but ultimately it's what's in the best interest of the child. The judge is not going to hear from the child, likely, given the age of the children matters. If you have a 17-year-old, the judge may talk to the child. But for the most part, judges don't want children in the courtroom. And so in order to get that evidence presented, you sometimes need a guardian ad litem or some other way to get that evidence into the judge.
Okay. So it sounds like there's ways, if one parent or the other is not really in the good interest of the children,
right,
then they'll look at that.
Right.
Okay.
And there can be, there can be concerns with drug abuse and that kind of history too.
Yep.
Domestic violence is another concern.
Oh, yeah. So then all that can be taken into consideration.
Yes.
Especially when it's concerning children. Right. Okay.
And it can get very expensive very quickly when we're bringing in these other parties, but it's the only way we can really present that evidence to the judge.
Wow. I guess based on that, then, what do you run into as far as common misconceptions around divorce, especially concerning, things like that need clarification when people come in?
A lot of times people are, the judge needs to know this, whatever it is, the judge needs to know, the judge needs to know, the judge needs to know. And the judge doesn't care. The judge doesn't need to know that. Our judges have thousands of cases. They don't have time to micromanage each case. And the hearings go so fast. You present the best evidence. The judge doesn't need to know every minute detail.
So it's like Cliff Notes time.
Yeah, I mean, it is amazing how fast it goes when you're in court.
And I'm imagining then, based on that, if you've got a divorce attorney that doesn't have experience with litigation
mm-hmm.
or mediation, that the focus could be directed to the wrong points that could have a really an effect on the outcome of that divorce.
It can get very frustrating. You don't have to have an attorney in a divorce. It's called pro se. You represent yourself. Mm-hmm. And it can be very frustrating dealing with a pro se person sometimes because they don't know the law and they don't understand what's likely going to happen in court. And I tell all my clients, I don't have a crystal ball. I don't know what this judge is going to do, but based on my experience, here's what I think should happen or what could happen. And when you're mediating or dealing, with an attorney that doesn't know our judges or doesn't know the process, it can be very frustrating. It actually happened yesterday for me. And if you're dealing with a pro se person that doesn't know the process, doesn't know, it can be very frustrating and very costly to your client because, again, I'm billing for my time. And a case that should resolve at mediation isn't. And now it's going to be a whole other process because trials, the prep work for trial, you have to plan on 3 billable hours for every hour of trial. There's so much work that goes into trials.
So I'm curious, when it comes to court costs, when you've got someone that's going pro se and maybe they're dragging things out, mm-hmm. Does the court ever look at that and say, this is costing the other client a lot of money and award court costs?
It can. So
or attorney fees,
right? With attorney's fees, it's kind of like alimony. We look at, do you have a need for a contribution, and does the other party have an ability to pay? Is the baseline for attorney's fees. However, we have what's called vexatious litigation. If you're causing a lot of litigation unnecessarily, then yes, the judge is going to consider that.
Okay. That's good. Otherwise, you just run into someone that, like you say, the judge needs to know this.
Right. And the judges, they just don't have time to micromanage cases. And it's interesting, but like I said, it just goes very fast when you're in court.
So from the perspective, and I wrote down mitigation versus litigation, what do you see the main benefits of, doing mitigation versus litigation?
Like mediation?
I'm sorry. I'm so glad that I'm speaking to a professional that knows what we're talking about. Thank you.
So like I said, I find that most cases can resolve at mediation. I like mediation as a confidential process. So the judge is never going to know what happens at mediation. I find that we can get more creative than a judge might do because the judge is going to follow exactly the law. And I'm not saying we go, outside the law, but we can get more creative. I also am collaboratively trained, which is the collaborative process is an agreement between the parties that we're not going to litigate this case. And it's handled a little bit different. And I find that the collaborative process can work really well as well.
Well, I wrote down collaborative when you said that. And what I heard is that people are committing to a favorable outcome.
Right.
And, as you said, it's more private. I see that as a benefit, just that in itself.
It is. It's more private. You're agreeing that we are not going to litigate this matter. You're keeping your financial information, the financial affidavits, out of the court file, that public court file. There's a lot of benefits to collaborative.
Okay. And then litigation, like you say, it seems to be more stringent. You don't have as much ability to be more creative.
Right. And I had said this earlier, you never know what the judge is going to do. I mean, I can advise based on my experience, based on the knowledge of the judges that I've been in front of, here's what I think will happen or should happen. But I don't have a crystal ball. I don't know. The judge could be having a bad day.
Yeah.
You just don't know. And so, and with that, again, there's the cost factor. Litigation is very expensive, and it's the uncertainty of it. You don't know what the judge is going to do. If you take your case into your own hands and resolve it at mediation, you know the outcome, and you've saved yourself a bunch of money.
What I'm hearing is risk versus reward.
Right.
Yeah, that's huge. And just the fact that you like to focus on mediation to begin with, it says a lot about your experience. What about real estate? Like, what factors should I consider when deciding if I should stay in a house or leave the house before the divorce happens?
It is. Oh, sorry. Real estate is such a big thing right now because, as you know, our real estate prices are up here, but so are interest rates now. There's no. I have clients saying, if I move out, I've abandoned the house. It's not a thing. You can move out. You're not abandoning your equity in the home. And certainly, if there's concerns with domestic violence, your safety is paramount. Get out of the house, or actually, you can file a domestic violence injunction and they would have to stay out of the house. But as far as, if you're planning on keeping the house, it probably makes sense to try to stay in the house.
Okay. So the party that wants to live there, and it could be both of them.
Right.
It makes sense for both of them to stay in the house if they both want to be there.
If it can be peaceful.
Okay.
So I'm having a lot of difficulty right now in several cases because of what I said earlier with the cost of real estate and interest rates. A lot of my clients have made very good financial decisions during the marriage, have great interest rates on a home, and have a lot of equity in the home. But the problem is, in order to buy the other spouse out, they have to refinance to get their spouse's name off the mortgage. I certainly would not want any of my clients to remain on a mortgage for a house that they're not keeping. So, and to get the equity out of the house, you also can refinance and get some cash out. But by the time you do that, the house is unaffordable.
Right.
So I have some cases right now where they have such a great mortgage rate, but they can't afford to buy the other spouse out. And so the thing you have to do is sell the house.
Yikes. Is there any workaround for that? Because I agree. I've seen where a lot of people are just not making moves in this market, because if I go from a 3% to a 7%, it's just not feasible for me to even own this home anymore.
Right.
Is there any workarounds, or like in a divorce decree that can cause that to be okay? Or
I have some mortgage experts that I work with, and I've often called him even during mediation, because there's certain language that you can put right in your marital settlement agreement that'll assist people with qualifying for refinancing. Particularly if it's an alimony case, there's a certain number of months that you need to be receiving the alimony. So there are things that we can do, and creative solutions. And again, it's good to have experts that you can turn to get the answers.
That's huge. That's what this podcast is all about.
Right.
I'm glad you're connected like that. So what about, like, recently I ran across a client who owns a home with his spouse, and he was like, well, Mark, I want out of here. I'm going to go buy another house. What would you say to that?
If he can do that, I mean, if he's going to need a mortgage on the house that he's buying, which most people would, I wouldn't want him to buy the house until after the divorce was finalized. Likely, if the house could be in his name alone, and he could be on the mortgage alone, but the mortgage company always wants the spouse to sign some paperwork, and I just think it's easier if you're divorced, and that way you're just a single person. The deed is, everything's clean.
So it sounds like there is a mechanism or a way that you could separate any factor of ownership of the spouse that he's leaving from that purchase. But again, they would have to agree, and they would have to sign it in the divorce decree.
Well, they would have to sign the mortgage, which not, and when I say that, they're not signing the promissory note. So they're not, making the mortgage can come after them, but I still prefer, I wouldn't want I don't want my clients signing until the divorce is done. It would be my preference if we can help it.
Okay. Got it. Well, and that's incentive to move things along. Okay. Lorna, you've been super, super kind with your time and your insight. And I think it's evidence as to how you work with your clients. And that's why I wanted to have you on this podcast today. So in closing, I guess, is there any other advice or something that perhaps we haven't touched on to someone that is considering divorce, particularly in terms of like legal counsel or communication strategies?
I mean, I always recommend, again, you don't have to have a lawyer, but I always recommend, speak to a lawyer. Don't make any major changes when you're pending or thinking about divorce. Don't go buy the expensive car right before you file, and keep the peace if you can, because particularly if there's children involved. If you're litigating a case with children, you've got the rest of those children's lives to somehow effectively co-parent with this other party. And trials can be so ugly that you're never going to be able to repair that relationship. But if you're able to take your case and keep the peace, think of your children first, which I'm finding a lot of people just aren't by their actions, and it's unfortunate.
I'm so glad you shared that. I wrote down, keep the peace and think of your children first. So when it comes to divorce, just like many transactions, there's really two components. There's the nuts and bolts. How does this happen? Technically, how can we get this through the process? And then there's another component that's just as real as all of that, and that's the emotional component. And I guess my question to you is, if you have a client that comes to you, and let's say that they're in a haze of emotion, and emotion usually only lasts so long, and yet if they're not coming down from that emotion, like they're in a state of victimhood or whatever, what would you suggest? Where are there resources that someone can go so they can keep that in check and maybe learn what they need to learn so that they can keep the peace?
Right. And, I deal with that a lot. And there's a lot of anger and hurt that comes along with divorce. And I always recommend go see a mental health professional. I make sure you're getting counseling to help you with these issues.
It's massive change.
Mm-hmm. It is. It is.
Well, that's meaningful. Well, Lorna, again, you've been so kind with your time, and you've been very gracious with insight. And I truly believe that, God forbid, if someone has to consider this choice, that you've shined a light on what's possible and maybe what to think about before they walk down this path.
Mm-hmm.
So I thank you kindly for your time.
Oh, sure.
I've always admired how you treat your clients and what you do. And if someone did want to get a hold of you or reach you, I imagine they could just go to your website.
Yep. It's Greater Orlando Family Law, gofamilylaw.com. And we offer a free 30-minute consultation. So I always just say, call my office, get with my paralegal, you get on my calendar. We can do same day sometimes. I'm not always available same day, but there is an attorney here that can do same day. And we're always happy to talk.
Thank you.
You're welcome.
I know you've helped many of my clients, and you care. So we appreciate your time today.
I appreciate it. Thank you.
My pleasure.